Yes. Okay, great. Welcome to everybody in the room. We are doing this hybrid, so I'm going to give 1 second just to make sure our online friends can catch up. And we can get them on before we do an intro, but y'all are looking fabulous. And I'll tell you, for anybody in the room while we're waiting for them, there's pieces of paper back there, some pens and note cards. Feel free to grab them if you wanted to be taking notes, and we'll talk about the note cards also, but there's plenty of them, so grab whatever you need to take notes. Yeah. Okay, so welcome. I want to say on behalf of the 1027 Healing Partnership team, thank you all for making the time tonight to come here, for choosing to spend the time to learn together. As we anticipate the coming federal trial, many people have many questions and some opinions. We hope that this experience will allow you all to learn more, likely leading to better questions and more informed opinions. And we believe that equipping more people with information like this will allow all of us to better support all who have been impacted by the attack on October 27, 2018. This is the first of a two-part series on the U.S. criminal justice system. A few housekeeping items. The first is that everyone should engage with this content in a way that feels comfortable for them. If you need to take a break, please feel free. The bathrooms are out the door and down the hall to the right. We are also offering this program in a hybrid format to facilitate multiple learning styles. So we'll do our best. Everyone knows at this point in the pandemic that hybrid is sometimes difficult, but we also are really happy that there's a number of people who could join us from out of town, as well as some of the folks who don't live as close to Squirrel Hill. So a few housekeeping, I already went through that. Anyone tuning on the screen, you will not be able to come off mute, but you can put questions in the chat that will then be relayed. The format tonight is going to be a little bit more lecture style, but you can put your question. So Professor Harris will teach first and then open up for questions. You can anticipate about an hour of teaching and then about 30 minutes of questions. We hope that these questions will stay focused on the topic discussed, not necessarily personal experiences or opinions. If you are here in person, we have note cards for you. Please write down your questions and then pass that card to the aisle when the presentation is over. You can pass as many cards as you would like. If you're on Zoom, please put your questions into the chat function, and Emery, our Zoom moderator, will then ask them. We'll take all of the questions and put all that we can on tonight. And then if there's some outstanding questions, then we will see if Professor Harris can address them next week at the beginning. So let me present our speaker. David Harris is the Sally Ann Semenko Chair and Professor of Law at the University of Pittsburgh's Law School, where he teaches criminal law and procedure and evidence. He devotes his research to the study of police conduct, search and seizure law, and the intersection of race and criminal justice. He's a leading national authority on racial profiling and wrote a book, Profiles in Injustice, and has many scholarly articles on the topic, resulting in news stories, new laws, and regulations in hundreds of American police departments. His most recent book is A City Divided: Race, Fear in the Law and Police Confrontations. And it tells the story of Jordan Miles' case, a case that took place in Pittsburgh. He's also the creator and host of the Criminal Injustice podcast, which enjoys a large audience across the country and around the world. Professor Harris is committed to using his work to create change outside of an academic setting, nationally, regionally, and especially locally tonight. In 2020, he served as the Mayor's Community Task Force on Police Reform in Pittsburgh, constituted in the aftermath of George Floyd's killing. He also served in Mayor Gady's Transition Committee on Public Health and Safety, and he's currently serving as Mayor Gainey's committee to select Pittsburgh's next police chief. In the fall of 2022, Professor Harris taught a class combined group of law students and incarcerated people at the State Correctional Institution at Greene as part of the Inside Out Prison Exchange Program. but he lives here in Pittsburgh in Squirrel Hill, and he and his family are members of Temple Sinai and Congregation Shir Tikva in Troy, Michigan. We're happy to have Professor Harris and his wife Rebecca here tonight. Thank you very much.
Thank you so much, Maggie. I'm just playing with my phone here because I want to keep myself on task and on time. So the stopwatch is on. I am so grateful to have the opportunity to be here with you tonight to do this work for the 1027 Healing Partnership. It is, Maggie and Renisa Davidson will tell you, when they asked me about this, I could not say yes fast enough. And I'm very, very grateful to have the opportunity to do this as a service to my community. Once I get this going, I'll really be doing a service. There we are. We're here tonight to talk about the criminal legal system and United States justice, and particularly how the legal system and how trials work. That's going to be our job tonight. But I think it would be a good thing if I could start by telling you first what we're not here to do. Okay? Because this, I think, will address, I'm having a little difficulty with this. I think this will address some of the lingering questions about how we're going to proceed. We are not here for the purpose of giving each other inside information on the trial. I don't have any, for one thing. For another, it'll all change by the time the trial comes in April of 2023. To tell you how the trial's going to go, to predict things. I don't have any way to do that, about strategy, about tactics. None of it will be where we will go tonight. The opinions that I might have, frankly, won't do anybody any more good than your opinions, no matter what they're about. So I'm not going to go there either. There are things we are going to do, though, despite starting that way. We are going to build knowledge here tonight for everybody in this room and for everybody who is with us virtually. Everybody who has been affected by these terrible murders. So the tightest concentric circle, the victims and their families, and then the next circle out and the next circle out until we get to all of Pittsburgh. Everybody has been affected and impacted by what went on. And when we know things, when we have the knowledge to understand what is coming, that will give us power. We know that the trial coming up, that is going to be difficult. We know it is going to be traumatic to hear all these stories again, not just for the people who are up there testifying. It'll be awful for them. For all of us, this is going to be difficult. So we build knowledge to build power to cope. When we have knowledge, it gives us a solid idea of what to expect. And that will help us to understand what's going on as it unfolds in real time. One thing about trial work, it always changes. It's a moving target. You never know what's coming next. And we have to know how the system works and what the ideas and the concepts and the rules are so that we can understand what is coming. When we do that, we will build our own resilience and strength as a community. And that's what's going to get us through this. That is what's going to allow us to cope with it and to understand it and to make something good in the end. There's no way that the actions 10/27/2018 could be anything good, but we will emerge and we will be stronger and we will have good ideas about what happened and why. So that's where I expect to go. That resilience is going to give us something that we can rely on together. And we're doing it together. There's value in that. Just being together and doing it. Why am I here though? Why is it me? What puts me here? That's a different question. Well, that's where I work, down at Buchanan Forbes. I'm a professor at the University of Pittsburgh School of Law. And I teach, as Maggie told you, criminal law, criminal procedure, evidence, all of those kinds of subjects that are quite pertinent. I've taught the criminal law class upwards of 40 times. over many years. This is sort of the kind of thing that I talk about all the time, but really that's only one reason I'm here. What I think of as the greatest gift of the job that I have, and the thing that I enjoy, and I think is the top part of what I do, is the ability to take what I do and bring it out of that building. I love the teaching in the law school. I love my students. I love writing my research articles and publishing them in academic journals. But what I really like is getting out and talking to people about the law, telling people what the real story is, how it really works. I've always done that. There's so much misinformation about the law and the legal system that it always seemed to me important to have somebody out there who could tell people, no, it's not like you see on TV. It's not like in the movies. And it's not like on talk radio. This is how it actually works. And that, again, is a way to empower people. And I've always done it, always written my books for general audiences, always taken great pride in my ability to talk to people who are not other academics or other lawyers. So that's when this opportunity came looking for me, I was also in a certain way looking for it. Here's the other reason. I am of this community. I am from here. When the terrible events of that October day happened, we were living 3 blocks, just a 3-block, 5-minute walk from that building. That's where we live. We now live across the street from the building we're in right now. So we've moved, but not out of the area, closer into the area. That is the congregation I belong to on the left side of the image, right? Temple Sinai. I'm from here. I'm part of this. And so the opportunity for me to serve this community at this juncture, to give something that can get people through it, was something I would never pass up. And I value very, very highly. So let me ask you another question. Why do we care about this? Why do we care what happens in this trial? Why do we care about understanding it? Well, there's, like I said before, the more we know, the greater power we have and the greater ability to cope. But it's more than that, I think, too. That building, this is actually 2 photos from the very same building. The building that you see on the left side of the screen, that's the U.S. Supreme Court. If you've been to DC, you've seen it. It's a marble temple to justice, the very embodiment. And when you get right up close to it, that's what is carved into the stone of that building above the door, above the entrance. It says, equal justice under law. Right? Equal justice under law. Now, I'm not naive. I've been in this business a long time. I practiced law before I taught it. That's an aspiration. It's not always reality in this country. We know that this country, and in its founding documents, all men are created equal, right? Oh, we left out the women. And what about all those people who were owned as chattel slaves? It was all white men with property are created equal. So we're a flawed enterprise from the beginning. And we have that carved up there in my mind to remind us of who we want to be, to remind us of the values that we have, even if we don't always get there. That's who we are. That's who we try to be. That's who we are in our best days. And so to me, it disappeared. I can still talk. I don't need pictures to talk. Why are we doing this? Why? The reason is not, why is there a trial at all? The reason for this is not charity towards a particular person or a defendant. It is not to make the sides equal. We have to have a fair trial, something like that. It is very much about values, and not the values of the particular defendant or any particular group. They're the values that we hold, our values. That's why we're going to get this right. That's why it's important that we understand the reasons what we're doing, for what we're doing here. It is our values to try to aspire to that idea of equal justice under law, right? And to have a trial that is fair and complete, no matter what we might think of any particular defendant, right? And for the Jewish community, it goes deeper, doesn't it? Right? I'm sure all of you have seen this at one point or another. Justice, justice shall you pursue, from Deuteronomy. Very famously, the late Justice Ginsburg titled her book with that same phrase. When there was reporting about her after she died or even before, sometimes she would talk about how she has a thing up in her office with that saying on it that she sort of thinks about a lot. Well, she's not the only one. I have one of those too. All right. My mother gave it to me of blessed memory. And that is important. All right. If the Jewish community sits at the center of this because of the nature of the crime, we must remember that. And I know that we all want to know why and how it all works so that we can pursue justice together. So here's what we're going to cover tonight. We are going to talk about some foundational concepts in the criminal legal system. These are definitions and understandings of things that often go unexplained. But my theory about teaching has always been when you understand the most basic aspects of something, the rest of it tends to fall into place. So I'm going to spend the first few minutes together tonight with all of you explaining some of these very basic concepts of the system. Then we're going to move to how a trial works, how the system works, and how a trial works. And I think all of that together with tonight as our first of 2 sessions will give us a good grounding in just what to expect. Remember, that's the goal. Knowing what to expect, understanding what's going to happen when the trial unfolds in April will allow us to face it with strength, together, and with resilience. Okay, so let's get moving. All right. Here's the most basic thing. The legal system in the United States is set up in 2 broad halves. All right. On the left side of this slide, you see the civil side, and on the right side, you see the criminal side. The civil side of the justice system is exactly what you would think of when you see all those commercials for Edgar Snyder, right? Or for any other law firm. It's people suing each other. It's disputes between private parties. The private parties may be individuals or they may be companies. So in a slip and fall, it's, because somebody didn't clear the ice off their walk, it's Smith versus Jones, right? In a contract dispute, it's A Incorporated versus the B company for breaching a contract. On the criminal side, which is where we're going to be for the rest of the night, we have cases in which the state, the Commonwealth of Pennsylvania, in our case, or the federal government, the United States, charges an individual with a crime, with an action that is so injurious, hurtful, and prohibited in a certain way in a criminal statute that the government says, you've done everybody wrong. It's not just A versus B. It's Pennsylvania, Commonwealth of Pennsylvania versus defendant. All right. And this is a huge difference in what happens. It's only on the criminal side that people can be criminally fined as opposed to a civil fine, but more importantly, go to prison or even something worse. All right. The civil side has no penalties as such. You may have damages and you may have money involved, but it's the criminal side that concerns us tonight. Okay. The next big divide in the system is between the state and the federal government on the criminal side, right? In the American legal system, on the criminal side, you have the state as an actor and the federal government as an actor. Now, for the vast majority of cases on the criminal side are on the state level. The state takes care of charging everyday crimes, the things that you would just think of off the top of your head, everything from murder to petty theft is charged by the state, right? The state runs all of the major prisons, like SCI Green, where I taught in the fall. If a crime takes place within a particular state, that particular state charges it. The charges are brought by the county's elected prosecutor, right? In the United States, prosecutors are elected officials, and usually it's county by county. A few states use districts made up of several counties, right? This is all happening on the state law level. Now, when we go to the federal side, they have criminal jurisdiction too for some of the same crimes, but mostly it's a limited pool of special crimes with a special federal interest, all right? That federal interest could be going over state lines. It could be federally regulated institutions like banks. Certain kinds of very large drug conspiracies are federal crimes. Special things that always end up in the federal system, well, not always, but often, white collar crime, right? Business oriented frauds, things like that. Government corruption, often charged federally. Large scale conspiracies because they're interstate. They involve people at many locations across state lines, and hate crimes. Pennsylvania doesn't have a true hate crime statute. The federal government has one, right? And then just to complete the picture, there are overlapping areas. So if you looked at this as a Venn diagram, the circles would intersect on a certain set of crimes, all right? So when you have the possibility of both the state and the federal government charging something, who decides, right? Who decides? Well, it's not clear, right? But you sometimes will have dueling state official and federal official, county prosecutor and United States Attorney's Office, that's who represents the federal government in any particular area, competing or arguing over who gets to bring the case. Could both of them do it? Yes, they could, kind of in sequence, one after the other. You wouldn't have them doing it at the same time. You may have heard today that the person behind the awful racist mass shooting in Buffalo was sentenced. He was sentenced in state court today to many life terms, but there's still the possibility that the federal government may come in and prosecute him federally, this time using hate crimes and some other statutes. So that can be done. If both are going, who goes first? It's often kind of a free-for-all. There's no real rules about that, but often one or another, our local prosecutor here, the Allegheny County District Attorney, or the Department of Justice representative, the United States Attorney for our district, one of them will just say, okay, you go first. They may have a reason for that, right? But both of them might be interested in having a whack at any individual case. Okay, so there's some big concepts. Here are some players and some definitions and some vocabulary. We've got to start with the judge. All right, everybody, you have a picture in your mind of the judge. Maybe you've been to court. I won't ask why. Maybe not. Maybe you've just seen judges on TV and in the movies. You know that they sit up at a big bench. They got that hammer called the gavel, wear a robe, generally speaking, in American courts. Thank God there's no wigs. I hear those things are pretty itchy anyway. The judge is in charge of running the court. All right. So they make sure that people behave, do the right things, that the lawyers do what they're supposed to do, and so forth. But even more important than that, the judge makes all legal decisions in the court. Now, getting into some tricky vocabulary, so I'm going to depend on you to keep me straight here. Legal decisions, we mean by that decisions based on the law, any particular aspect of the law. It might be whether this charge is the right charge. It might be whether this evidence gets in when it's maybe hearsay or something like that. What the judge isn't doing, if there's a jury involved, the judge is not deciding what happened. The judge is not deciding which witnesses to believe. The judge is making decisions based on the law and not the facts. This is one of the great divisions in American jury trials, right? Judge runs the law, instructs the jury on the law. We're going to talk about some more of this as we go along. The jury takes care of what happened, the facts. All right. So the judge is in charge of all the legal matters in the court and runs the court, and don't get in the way because they got that hammer. Prosecutor and defense attorney. Remember, we're on the criminal side. There are people, lawyers representing the government or the state. Those people are called prosecutors. They prosecute the case for either the county, the state, or the federal government. They are called the prosecutor. And you've got the defense attorney. Defense attorney is there to defend the accused. These lawyers, you can see, I picked this is not a great picture. It was pretty hard to find the right one for this, but I picked this to show you them separated. You see those two tables in front of the judge? The table closest to the jury box on the left, that's the prosecutor. Table on the right, that's the defense attorney, right? They are separated. And it's not just symbolically. They're doing different jobs. They have an overlap in their jobs, but they're doing something different. The job of the prosecutor is to represent the government and bring the government's prosecution case. We'll talk a little bit more in a minute about what that means. The prosecutor also has the job of seeing that justice is done. All right. We say that this dual role is the role of minister of justice. Well, what does that mean? That means that in any particular case, a prosecutor might look at a case and say, you know what, this is weak. We should drop it. You know what? We should offer a plea bargain to something lower because it's just, the facts here don't justify such a harsh charge. Whatever it is, those kinds of decisions are the prosecutor's responsibility. So in other words, the prosecutor doesn't only have the job of winning for his or her side. Has those two roles. The defense attorney, one role, represent the accused. It is not up to the defense attorney to help the prosecution. It is not up to the defense attorney to do anything except zealously represent the accused within the law. That's how it works, right? Now, why does it work this way? Right? We're going to come to that in a second. Here's our jury. Now, juries are very rare in the world. Most countries don't use juries. Not all countries function the same way in their justice system. But a jury in a criminal trial decides the facts. Remember, that's how the judge and the jury go together. As I was saying a minute ago, the judge decides the law, the legal questions, helps the jury understand what the law is and what law to apply. The jury decides what happened, which witnesses to believe, what they think went on. All of that is within the hands of the jury. I'm going to talk some more in a few minutes about how we select the jury, how it's determined who's there and what goes on. But that's their job. So in terms of the basic roles, the judge is a neutral, right? That's the way it's supposed to work. Sometimes it doesn't. We know that. All right. The judge is neutral, doesn't represent anybody, runs the courtroom, makes sure that the rules are followed, and makes sure that the law is followed. The two lawyers, prosecution and defense, they represent, on the one hand, the government, the state, bringing the prosecution, and the defense represents the accused. And the jury hears it all and decides what happened after instructions by the judge. And that brings us right here, the adversary system. If you don't understand this, you won't really fully understand who those players are and why they do what they do. In our justice system, we have it set up the way that England did when the 13 original colonies were founded first as separate states and then as the United States. They use an adversary system of justice. What that means is, again, the judges are neutral, but both sides are there to challenge each other. The essence of the adversary system is a kind of challenge over what happened. Each side brings its own evidence into court. The defense attorney is not in charge of helping or not charged with helping the prosecutor gather evidence. Prosecution brings its own evidence. Defense may bring its own evidence, and they challenge each other. The idea is that by challenging each other, the jury can see the strengths and weaknesses in each side. Each side's strengths and weaknesses are exposed for the jury, and that helps the jury decide who's telling the truth and who's not, and what really happened. We make the assumption that there is no one story. The governing assumption in our system is that there can be a story from each side. And the judge doesn't have any part of that. The judge sits up there, runs the court, runs the law, but the judge doesn't present any evidence. Now, this is quite different than in a lot of other countries. The continental systems, the big European systems, France, some other countries, the judge is not really a judge fully in the sense that we think of a judge of being that neutral party, right? The judge is a sort of a hybrid of a prosecutor and investigator and judge and all kinds of things mixed in. So there's no magic to this idea. You can't say that every country runs like this. Every country's court system runs like this. This is just how we do it. And I won't stand up here and claim this is the best in the world all the time for all purposes. Maybe it is, maybe it isn't, but it is the way we do it. And you have to understand that they're presenting different cases and they're challenging each other and they're opposing each other in that courtroom because the way the system is set up. That's why the lawyers and the judges and the jurors do the things they do. They have roles within that system. And so, I'm so sorry to hit you. Please don't make more noise at me. Adversary system. Now we go on. All right. Evidence, an important concept. When I use it, since I teach a subject called evidence, for me, that often means the rules and the laws for proving things in court. Tell the students on the first day, evidence is how you prove stuff in court. But really for us, the meaning of the word is different. It's the actual proof itself. The proof is what we call evidence, all right? That proof is most commonly what you see on the right side of the screen. You see that man? He's in the witness box. You see the judge in the background there. That man is testifying. Most evidence that comes into court is testimony. It's testimony and stories and words of witnesses. Another piece of evidence there on the left, it could come in that form, a document. That's actually a transcript that's lifted out of a deposition taken of a certain defendant named Cosby. This is something that kind of sunk him when he finally went to prison. Right? That can be evidence too. And the evidence can be a firearm. It could be a fingerprint. It could be anything. All those things are evidence. When we watch TV and the movies, we think of the things, right? But the evidence is much more commonly people telling the story in response to questions from lawyers, right? That's what we mean when we say evidence. Now, another big concept. We call this in criminal law the standard of proof. What we mean by that is basically who has to prove what and by how much. All right. So let's take this apart. Let's talk about one of these things at a time. All right. In a criminal case, who has the job of proving things? The prosecution. That's the really simple answer. You don't have to read all that stuff on the screen. The prosecution has to prove the case. They have to prove the case. The defense doesn't have to prove anything at all. The defense can stand silent and just say, go ahead, government, do your worst. Doesn't have to bring a witness, doesn't have to testify, nothing. It's all up to the prosecution. Why? Because the prosecution brings the case Prosecution is asking that jury to say, this person is a criminal, that person is guilty. And we know certain things follow, right? The person can be thrown into prison. The person can lose their freedom. We want that. Somebody's going to have to be in charge of doing that. That's the burden of the prosecution. They must prove the case. What do they have to prove? So who has to prove what? They have to prove all the elements of all the crimes charged. Right? What is that? Elements. Let's not get technical here. I hear you thinking, right? All this means is that if you look up any crime in the state's criminal code, any crime, there will be a statute and it will say anyone who, and then it will enumerate doing certain things, is guilty of fill in the blank. So here's an example. All right. Common law burglary. We don't have common law crimes anymore. That's why I picked that one. It's the same in every state. All right. If we use the oldest kind of burglary, the elements would be to break and enter the dwelling house of another person at night, sometimes they say, with the intent to commit a felony inside. All 5 of those things must be proved by the prosecution. All 5 of them. They have to have evidence, whether it's in the form of witness testimony or something else, that the person broke in, that they entered, and it was a house and it belonged to somebody else. You can't burglarize your own house under that statute, right? With intent to commit a felony. They have to have evidence on each and every one of those. The prosecution. And by how much? Beyond a reasonable doubt. Beyond a reasonable doubt. This is a key aspect of our system, right? It's constitutional law in this country that the prosecution must prove each element of the crime beyond a reasonable doubt. Now, you'll hear a lot of definitions in a lot of courtrooms of what exactly this means, right? It doesn't mean proof beyond all doubt, just proof to a moral certainty. I used to tell juries, just, is there enough evidence that you'd be willing to make a really important decision in your own life? That's proof beyond a reasonable doubt. So, who has to prove it? Prosecution. What do they have to prove? All the elements of each crime beyond a reasonable doubt. So, how are we going to think about this system? I suggest a funnel. Right? Let's talk about the system itself. Right? A lot of people think about the criminal legal system as a giant pipeline. You heard that, that metaphor sometimes. I like this. More to the point, I like it this way. A giant funnel that looks like it's laying on its side and it leaks. Now we're really stretching the metaphor out of shape, right? Go with me here, all right? Just hang on. What I'm talking about here is a system in which there are a certain large number of crimes. Fewer of them are reported than happen. And in fewer yet is there an arrest. And then the cases start to get dropped, people plead guilty and so forth all along the way. So that by the time you get into the end, where the trials happen, it's a pretty small opening. All right. So if you like it in graphics instead of in a picture, huge number of crimes reported or committed, a smaller number reported, and then a smaller number yet arrests made. Some cases are charged. There's a bail, and then all along the way, guilty pleas. Guilty pleas. That's why the funnel leaks. Cases are dropped. People plead guilty as they're allowed to do. There's nothing wrong with that. Right? And you get to the really tiny print at the bottom. There's your trials. Right? So that's why I say it's like a funnel on its side. All right. Crimes committed, crimes reported, arrests made, and so forth. And all the time, the numbers are going down, down, down until you get all the way to the end. That's what the system looks like in the macro sense. Right? That's what we're looking at. So what about all those leaks, plea bargains? Now, cases leak out of the system for a lot of reasons. I told you sometimes prosecutors drop cases. They do. They do. Sometimes a defense attorney will make a motion, move to suppress the evidence. Rarely succeeds, I can tell you that. But it does sometimes. Case drops out of the system. Most cases drop away, though, because of what we call a plea bargain. All that is an agreement between prosecution and defense that there is, based on the evidence that was brought in, there's some way to resolve this short of a trial. If the court can save the time and resources of bringing in a jury, taking up a courtroom for 4 days or a week or whatever it is, having the lawyers there, having the witnesses go through it, if they can avoid all that by simply having a person plead guilty, the court likes it. It takes cases off the docket. But why do the other parties like it? The prosecution, if it offers a plea, a bargain, if you plead guilty to the top charge, we'll drop all the rest. There's a typical sort of plea deal. Or if you plead guilty, we'll agree to recommend a sentence of thus and so. All right. The prosecution gets a guilty verdict out of that because the end result of a plea bargain is a guilty verdict that is just the same as the end of a trial, except it's certain. It's certain guilty, whereas trials can go any way. They do. Right. And the defense lowers the risk of being found guilty of something more serious and gets it to be something less serious. Right? They get a break on the jail time, whatever it is. This is the way that the vast majority of cases are handled in American courts. Some people say that that's a shameful thing, that there should be a lot more trials. I think we could have a lot more trials in our system. We could. It wouldn't strain us at all. It would make judges work a lot harder, and I don't see anything wrong with that. Do you? But we don't. This is how we resolve most cases in the system. When I say most, 90%, 95%, in some places, 97%. So it's the smallest number. Like I said, see the tiny little word trial? That's why it's so tiny. Right? Okay. So here we are. So far, big concepts, why we do this, the major actors, what their roles and duties are, the burden of proof, the idea of the system, the giant funnel that leaks cases out, right? Plea bargains. Now let's get to talking about how a trial works, right? Because we're going to have a trial in this community. We're all going to hear about it. And it will help us to understand exactly what's going on, right? Why it works the way it does. Right? I can tell you from having tried many cases myself, it is a very fast-moving thing to be involved representing somebody in a trial, even when to any observer, it's just crawling. For lawyers, it's a multi-level game all the time. Lots is happening. This is one of the reasons we can never predict the outcome very well in any given case. And we would have a lot of trouble telling anybody, well, here's how it's going to go. Right? But there are things we can know. There are things we can understand. And that's where we're going now. Here we go. First thing that will happen, this guy. All right. Who's been that person? Right? Yeah. I might be the only one who hasn't reacted that way. I would love to be on a jury. And every time I get summoned down there, they ask me what I do and they say, thanks, goodbye. All right. So people get summoned for jury duty. They get called down to the courthouse. The usual systems in most places are come down for a day. If you don't get picked for a jury, you can go home. Your service is over. Better than it used to be. But you have to summon some number of people every day, and it's only determined the day before when they know how many cases look like they will go to trial. Right? They summon a certain number of people down, and you got to go. You got to go. Right? These people all have to show up in court. They become the jury pool. Right? The pool of people who will be selected for one or another trial or not at all. right? We draw a pool of people together. We show them a video down there and we ask them some basic questions. In most circumstances, you're going to get a very brief questionnaire like the one on the left side of the screen. The questionnaire will ask you a certain number of very basic kinds of questions, demographic questions, and where you live, and some other things. You can see it's not very long. In some cases, though, and the more notorious the case, and the bigger the issue, the longer you might have. I said that wrong. You might have a very long questionnaire, right? And in a case that is very notorious, that a lot of people know about, that's been in the news all over the place, and that has some very volatile, real questions of law, you can get a very substantial questionnaire to fill out. It can be, 80, 90, 100 pages even. All that goes back to the court in advance. You fill that out, you mail it in, then you go down on your day. Then when you get down there, they might separate you into a group and you get called into a courtroom. And then instead of questionnaire, it's questioning. All right. Questioning begins to screen jurors to see who might be a suitable juror. Again, the more notorious and well-known the case, the larger the number of people going to be in that courtroom answering questions. Right? The whole objective, this process is called voir dire. Voir dire, and that's some fancy foreign language that means to see, to say. All right. And you see the people who are, a question is being read out to the courtroom. Anybody who who knows any of the following people, please raise your hand. Right? The prosecutor, Ms. Jones, the defense attorney, Mr. Smith, the defendant, and they all stand up and so forth. And a few hands will go up. Right? They might read the names of witnesses for that same purpose. Right? You want to know who you might know. And if you know anybody who's really close to the case or the lawyers, you're probably going to get dismissed. But these questions will go on. And all the time, they still have your questionnaire, right? They have all the information on your questionnaire as well. Some of the more sensitive kinds of questions, you won't answer out loud in the courtroom in a group. And what kind of questions would that be? Has anyone here ever been the victim of a crime, accused of a crime, or, things along those lines? Okay, the hands go up, but don't answer out loud, right? They'll call you up one at a time. They ask those questions in a bunch, so nobody can tell exactly who's answering what question when their hands go up, right? All of this information gathering is coming to the lawyers. For what purpose? The idea is you want to know who the potential jurors are, right? There are two ways that jurors might get screened out. Way number one is what we call bias, right? It might be something like, when we say bias now, we tend to think of racial bias or gender bias or something like that. And it might be those things. A person might show those kinds of attitudes in answering some of the questions. More likely it is something else, right? It could be knowing the parties. I work for lawyer Smith. What do you want from me? That's a bias, a potential bias anyway. But it might be your attitude about a particular kind of crime. It might be your attitude about whether you believe police or not. It could be a lot of different things. And what the court is trying to do is to screen out people who have such obvious biases that they cannot serve fairly. The old saying about juries, you get a jury of your peers. No, that's a saying. It's nothing more than a saying. What you get is a fair cross-section of the community. That's what you're supposed to get. And then people are supposed to be able to say, yes, I could judge fairly. If they can't say that, or if there's reason to think they cannot judge fairly, that they're biased, they should be excluded. I said there are two ways that a juror can be excluded. They can be excluded for cause when their bias shows up. And then they can be excluded for no cause. Now, there's a fancy legal terminology for that, peremptory challenges. We don't have to get to that level. What that means is that lawyers on both sides will have a certain number of no excuse rejections that they can use. on the potential jurors, right? The person looked at me funny. Person, is wearing a tinfoil hat. I mean, make it up. It could be anything, but it could be also things on that questionnaire. Okay, they passed the bias test according to the court. Court wouldn't excuse them for cause, but there's something I don't like about the fact that that person works at a newspaper, in a press office, in a plumbing contractor's office, anything. And so the lawyer can use their no excuse challenge, their peremptory challenge, to get rid of a certain number of them. Now, they cannot do that based on race, ethnicity, gender. I think that's an exhaustion of the relevant categories. They can't do that. But otherwise, they just take them off. And, when you're going to do that, you better know that the next person who's going to be seated from the pool over there is going to be better. All right. So it's a risky business. Selecting the jury. Now the jurors are sworn in. The trial starts. Begins with opening arguments. You see the lawyers there making their opening arguments to the jury. One important thing to know: this moment, the lawyers are kind of they're giving the jurors what you see. You ever open a jigsaw puzzle, right? And the top of the box that tells you what it's supposed to look like when you're done. That's really what they're doing. They're giving them the whole picture. Here's what the evidence will show, right? Because it's going to come in bits and pieces through different witnesses. It might not be clear as they're going along. So they give you the picture. Both of them do that from their respective points of view, prosecution and defense. Don't expect them to look the same, right? And the other thing to remember about this, what the lawyers say is not evidence. It's what the witnesses say that is evidence. This is just lawyers talking. They're trying to persuade, all right? The witnesses are the most important people in court. Absolutely. And I have to say, really, because there are other people who think they're more important. That person with the black robe, for one. The lawyers often, right? But really, it's the witnesses. Without the witnesses, you don't have the case. The witnesses give the evidence. You can't get the object, the gun, the knife, whatever, into evidence without a witness to testify. This is the gun, right? Witness may be an expert, maybe a layperson, maybe a police officer, just a person who saw something on the street. Whatever it is, witnesses are the key. Lawyers ask the witnesses questions. Now, if you've seen this on TV, you've seen the wrong model. That's all I want to say. All right. How does it work? The lawyer who calls the witness, this person is my witness. I'm calling the witness to the stand. That person asks the witness what we call engages in direct examination. What does that mean? It means the questions have to have a certain form. If it's your witness, you cannot give them questions that imply the answer. So here's how it works. So, Mr. Witness, were you at the following location on the following day? Yes, I was. Did you see anything unusual? Yes. Tell us what happened. Well, blah, blah, blah. Then what? What was the next thing you saw? And what happened after that? Did you talk to anyone? Did you see anyone? And then what did you do? It's those kinds of questions. They don't lead the witness to an answer. And that's a requirement of the way you talk to your own witness. Then it's the other side's turn. You've seen this, right? You're a witness, says the lawyer. And then the other one gets up for cross-examination. Cross-examination. Now the questions change. Now it's all leading. All of it is leading if the lawyer is doing her job. Right? So, Mr. Witness, you were at this particular place and at this time. Is that right? Yes. Now, you said you saw this important thing happen, didn't you? Yes, I said that. Now, I notice you wear glasses, Mr. Witness. Isn't that right? Yes. And you wear glasses for distance, I understand. Yes, I do. And I also understand you didn't have your glasses on that occasion. That's correct, isn't it? Yeah. You get the idea? The witness is controlled by the questions. That's how cross-examination works. Now, we remember the adversary system from a few minutes ago? This is the embodiment of the adversary system. This is how the lawyers are challenging each other's cases and witnesses as they go along. It is completely appropriate. It is what all lawyers do in every single trial that's ever taken place. Right? Now, just so you know, cross-examination usually doesn't look and feel like what you see on TV and in the movies. There's nobody is getting their throat cut up there. You know, witness in person is basically dead from the sharp questioning. It's not like that. But that is the form the questions take, and that is the purpose of it. It's to challenge the other side's case. That's how it works. So when you see or hear about or read that the lawyer for the defense was zoning in on this particular witness and asking him hard questions, that's what the lawyer is supposed to do. That's how the system works. That's how the challenge is performed. You have police sometimes, you have people who are just there observing, and you have often victims. Victims, it used to be when I came up, all right, victims were witnesses if they were useful to the prosecution or occasionally the defense, but that's all they were. They could testify about what happened to them in the respects that were relevant to the trial. That has changed. That has changed dramatically in the last 20, 25 years. Victims can give that kind of testimony, and they will and do all the time, but they can also, under law, talk about the impact of the crime on them at the proper place in the trial. And I'm going to talk about that in a few minutes. All right. Not during the trial itself, not during the guilty or not guilty parts of the trial in sentencing, but they're entitled to have notice, come to court, and give their statements about the impact of the crime on them. That is relatively new in the creaky old legal system. Right? What about this guy? You ever see lawyers do that? They stand up and say, objection. And they start talking over the other lawyer, over the witness. Right? Again, it's part of how it works. What the lawyer is supposed to do there is when the lawyer hears that evidence is about to come in from a witness, and that evidence should not be allowed because of the rules of evidence or something else, the lawyer should be getting up on his hind legs, get ready to bark before the answer comes out. Say objection. All right, right away. And you cut the question off and you say, Your Honor, that would be hearsay or something, whatever it is, whatever the objection is. You're giving a legal argument in a word or two, is what I tell my students to do anyway, that tells the judge, you can't let the witness say this. Right? And then the other lawyer stands up and they argue to the judge about who's right under the law and which exception might apply and so forth. For lay people, this could look like, hey, that guy's trying to keep the jurors from hearing the evidence. Well, maybe he is. That could be true. But it could also be true that the jurors should not hear the evidence because of a rule of evidence or some other aspect of the law. Right? So again, adversary system at work. This is what that lawyer is supposed to do. Not in all cases. They don't have to object anytime the rules might be violated, but that's their job. Right? And is it motivated by what they're trying to get to happen in the case? Of course it is. That lawyer's job, if that lawyer represents the defendant, is to defend the accused. And if the lawyer can help defend the accused by keeping out certain evidence, then get up and object. That's the way it's supposed to work. That's what we should expect to see. That, by the way, I wasn't trying to advertise for that law firm. I just thought it was the best picture I saw. Okay. How about this? Have you seen this? Right? The lawyers get up and they say, Your Honor, can we come to the bench? Can we have a sidebar? Can we have a conference? And up they go, and everybody huddles into a little corner of the bench where the jurors can't hear them. And you see down in the lower left of the image, you see the court stenographer is there because that person is still taking the stenographic notes. Right? So it's still part of what's going on in the trial, but this is a very deliberate effort to try to make a legal argument that maybe you can't make just by standing up and saying, I object, or you don't want to say it that way or something. And you come and you have this sort of private little conference with the judge. This drives jurors insane. They hate it. The court where I did most of my trial work, when we would come up for a thing like that, they actually had a white noise machine that hung at that angle of the bench. They would turn it on so the jurors not only didn't get to hear what was going on, they got for 10 minutes. You can imagine how they like that, right? But again, this is standard. You will see this over and over, and it will annoy people, but it has to be done. You understand why? That's the key. Okay, so now the prosecution, which had to go first because they prove everything beyond a reasonable doubt. Now they're done. Now they rest. They say, that's all of our evidence. Now it's the defense's turn. But remember that the defense doesn't actually have to take a turn. They get up and can do nothing. They can say, Your Honor, we rest. Your Honor, we don't have any evidence. Or they can put on any evidence that they want, right? There's no need for the defendant to testify, right? It's a constitutional right to testify or to not testify, if you so choose. That's how the system works. Why? Again, we have to go back to values, right? We value the fact that the government, the most powerful entity in our society, is trying to put this human being in a cage. And we don't let that happen except with a lot of due process. And this is part of due process. Now, if the defense wants to put on a defense, now it's their turn, right? What kind of defenses? An alibi, self-defense in an appropriate case, something like that, an insanity defense, maybe, all of those things. And if they choose to do that, now they have to prove the elements of those defenses. Right now, so if they're going to put on a self-defense case, there are elements to self-defense just like there are to burglary. And it's up to the defense to provide the evidence to show, yes, there's a reasonable case for self-defense. And you should find the person not guilty. It's their burden at that point. All right. Same rules with witnesses, same calling the witnesses. Now, when the defense calls the witnesses, they ask the direct examination question and the prosecutor cross-examines. One thing that a lot of people wonder, should the defendant testify? Or in any case you can think of, why didn't that guy testify? He's having a trial. Why didn't he get up and tell the story? The jury wants to hear a story. Who doesn't? Right? Well, let me explain. We know already he doesn't have to, but that's only his right. Why would he not do it as a strategic matter or a tactical matter? The jury does want to hear, and sometimes there's no choice. If you've got that self-defense case in which the accused and the deceased went into the dark alley and only the accused came out, and now the accused is saying self-defense, nobody else was there, the accused has to testify. Sometimes there's no alternative, right? But when there is any alternative, as a former defense attorney, I'm telling you, there are reasons to hesitate, right? They make very poor witnesses. Even the ones that are telling the truth make very poor witnesses, right? They may be telling the truth, but have a criminal record that could be brought out if they testify. This is a real risk in front of a jury, okay? So if the case can be done without the defendant testifying, you will often see that. Again, it's standard. This is not something that should make us think, why? Oh, that means, no, it's a strategic decision. If it's up to me, anytime I can make my case without the defendant testifying, I almost always do it. Others may differ. That's an opinion. All right. So now the defense case is over. The judge tells the jury, here's the law that you will apply. It's the law of burglary. It's the law of homicide, murder, manslaughter, whatever it is. And you, jury, will apply this to the witnesses and the evidence you have heard. It is up to you to decide who to believe and who not to believe, to decide how much weight to give the evidence. And if you find that there is evidence on all the elements of this crime beyond a reasonable doubt, you can find the defendant guilty. There is not such evidence, you must find the defendant not guilty. A lot more that the judge talks about how deliberations work and so forth, but the judge gives them those instructions and off they go into the jury room. locked in there. Nobody gets to go with them. These days, they're often instructed, don't Google anything, right? Don't be doing your own investigation, right? Actually, quite important. You have cases going down the tubes all the time because people bring in their phones. Hey, look, the guy's got a criminal record. I know how I'm going to vote. We vote now. Do we still get a free sandwich? You know, things can go wrong. All right. They're given very specific instructions on how to do this, and they're locked away. If they can come to a conclusion, it must be unanimous. All right. If it's a 12-person jury, all 12 must agree that the evidence is all there. Sometimes they can't come to that kind of agreement, and they might tell the judge, "Judge, we're stuck. We can't resolve this. We don't have full agreement." And the judge will usually send them back in. No, try harder. Give them what's called a dynamite charge, exactly what it sounds like. Reconsider your beliefs, see if there's some way you can reach, blah, 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 blah. But if they come back 2 or 3 times and say, "Judge, we just can't do it," it's done. The judge will say, "Okay, this is a mistrial. Go home. Prosecution can try again." But if they do come in, they read a verdict. The judge will have the foreperson stand up. "Have you reached a verdict?" "Yes, we have." We, the jury, find the defendant guilty on count 1 of first-degree murder, whatever it is. Or we find the defendant not guilty. And then, if there is a guilty verdict, we get to the sentencing phase. Sentencing usually doesn't happen on the same day. Usually follows 10 weeks, 2 months, 3 months, something like that. There's often a detailed report done by some folks in the court bureaucracy. A defendant's background, defendant's criminal record, the offense the defendant did not take responsibility in our interview, blah, blah, blah. The defendant may wait in jail for the sentencing date, and then the sentence is pronounced. When it's finally time for the sentencing, that is the time when victims may speak. They may give their statements to the court about what the impact has been on them. And so I think we have reached the point where we're ready to get questions. Almost. Because you know what we're supposed to be here for, right? This is supposed to be about justice, right? You can see something when you look at these images, right? Lady Justice with the scales, right? Blindfolded, the sword of justice, all that. Equal justice under law. And I think I started us by saying these things were aspirational. And I believe that, right? I believe that we must aspire to pursue justice, all right? I don't believe we get it right every time. I don't believe we can, because we're all human beings, right? But we have to try. That's what makes us different. We have these aspirations and we can try. The jurors, we're all human beings when we sit on a jury. We do the best we can. We serve as a witness. As human beings, we do the best that we can do. Or whether we're judges. These are all human beings in a human-created system. Our symbols are great, but it's really those people. Us, right? And that's why I come back to this every time. That's why I'm glad I have it on my office wall. It's about who we are and our values. That's why we do all that stuff. That's why we pay attention to rules. That's why it matters. Not because of somebody else, because of who we are. Now I'm ready for questions, but special thanks to these people right here, some of whom are in this room. All of whom actually are in this room. John, Jeff, Marshall, and especially Maggie and Renisa. I thank you for bringing me to this occasion. I really appreciate it. I see cards being handed up with questions on them. That's the way to do it. And we'll get some questions answered.
I'm going to start with a question from the Zoom, please.
Okay.
What happens during the pretrial phase of a criminal trial?
What happens during the pretrial phase of a criminal trial? We're talking about the pretrial phase. We generally mean the time between the filing of formal charges and the time when the case would actually come to court for a trial. In that time, you could have a number of things happen. People could decide to enter a guilty plea after negotiations between prosecution and defense. People could move for various kinds of judicial relief. They could take the form of a motion to suppress the evidence, to throw it out. That evidence could be the drugs. It could be a confession. It could be any number of things. There are reasons sometimes that charges themselves will be thrown out because they were arrived at in a defective way. It is, in a nutshell, it is time for legal rulings. The pretrial phase is all legal rulings by the judge that may impact the shape of the case going forward, the amount of the evidence, or the existence of the case altogether. Any of those things can happen. Think of that funnel getting pretty narrow. That's happening in the pretrial phase.
Do you know the rules for a courtroom trial with juries about the spectators in the courtroom? Which members of the press may attend?
So this question is about the people who are spectators in a courtroom. This is one of the things that is governed by the individual judge and the individual court system, the particular county or federal court in which the trial is taking place. It will all depend on the demand for seats in the courtroom. Often in a very famous or notorious case, you will have more people who want to sit in the courtroom than there are seats. There may be overflow rooms in which there is video feed for that purpose so people can see it. There is usually space for press. Sometimes, again, in a very crowded situation where there's a high demand, there will only be a certain number of press seats. They'll have to rotate them among the various media folks. It is really all governed by the judge in charge and that particular court, the Western District of Pennsylvania Federal Court, let's say. So it's local rules, local judge.
When picking the jurors, do both sides have to agree upon them? What if the defense wants one and the prosecutor does not?
Great question. When picking the jurors, do both sides have to agree on them? The answer is no. And you can easily imagine how the prosecution may want a very different kind of juror, a person with a different background or different set of beliefs or experiences than the defense would, right? Some of this is like old folklore with lawyers. You know, you want this kind of person for this kind of case. And most of that is baloney. Right? And it's been shown to be, you know, scientifically proved that it's baloney. You look for people's beliefs and experiences, and that's what they're revealing often in those questionnaires. And so it would be very, very common for prosecution and defense to disagree. And so if the prosecution and the defense, they're arguing about whether a particular juror is biased, they may be on very different sides of that question. And whoever wins the argument, that juror is kept, that juror is excused. When they use their no excuses, those, hey, the prosecution might take off a juror that the defense really wanted, and the opposite can happen too.
Why or why not is a criminal proceeding televised?
You're looking at the first and only person who ever wrote a full-scale law review article about what used to be called court TV a long time ago. It hasn't been called court TV for a long time. There's no court TV anymore. But I was very interested in this for a long time. And there are a certain number of people here that I can tell would have been around for not the entertainment vehicle O.J. Simpson trial, but the real one, right back in the early 90s. And that was a circus. It was, in every respect, things really went off the rails. And I think having it televised was a big reason. I think that's the lesson that court systems across the country took from that. So you find in federal court, cameras and television highly restricted. We'd all like to see the Supreme Court doing its hearings, right? Nah, They're never doing that. They're never doing that. State courts can have their own rules, and then within states, judges can create their own rules within the system. The constitutional rule is that courts have to be open to the public. You really rarely find a judge closing a criminal justice hearing or a trial. But open means people can walk in. It doesn't mean there have to be cameras.
Who has input into sentencing?
Sentencing, here's another big divide, and we're going to, of course, get to this next week in real depth. If it is a non-capital case, so anything but a death penalty case, sentencing is done by the judge. There are certain little state exceptions to that here and there, but it's pretty much the judge. That's the rule. Right? So the judge pronounces the sentence. The judge is hearing from and making up her mind, the victims, the prosecution, the defense. Everybody gets to make an argument, but it's the judge. A death penalty trial, a capital case is different because when you get down to it, there are two trials for a death case. One is the guilt phase. We'll be doing all this next week. The guilt phase, and then it's the penalty phase. And the jury is going to decide in a capital case whether the defendant is sentenced to death or to life in prison without parole. That's the role of the jury in sentencing.
Kind of going along with that, can a defendant or prosecutor choose a plea deal at any point in the trial?
Yes, pleas can happen up to the morning of the trial, and even during the trial, they can decide, you know what, this isn't going so good for me. I wonder if there's still a deal out there. But the further on you get, especially after a jury is sworn, it's going to be pretty rare where you see a plea during a trial. It does happen occasionally, but most of it is before that.
Why are victims only allowed to speak at the sentencing phase? Hasn't the decision already been made at that point?
Victims are allowed to speak in terms of giving testimony during the trial about what happened and what their experience was. The new part of this that I was talking about was victims describing the impact on their lives, their family lives, their communities, and things like that. And that happens at the sentencing phase. Has it already been decided? In some cases, the answer is yes. We were talking just a little bit earlier about the sentencing in Buffalo today. There was no mystery about what the sentence was going to be in that case. It was going to be a certain number of consecutive life sentences. And it could not go any other way. There is no capital punishment in New York State, and that's that. And he was convicted of crimes that call for life sentences. But the function of the victim impact statement is not only to influence the judge. That is a big factor. It's something that's designed to do. And nobody could rule out the fact of a judge, the possibility of a judge walking in for a sentencing and already having the judge's mind made up. But there's another function too. They get to tell the whole world what was done, the damage that was done, why this was the crime that it was for them. So that should be considered as well. What is a motion to suppress the evidence? Motion to suppress the evidence. This comes from the Fourth, Fifth, or Sixth Amendments to our Constitution. Depending on the type of evidence, it will be all about one of those pieces of the Constitution. Fourth Amendment, no unreasonable searches and seizures. Fifth Amendment, the part of it that we're thinking about right now is that you can't be compelled to give a statement against your will. You have to be given Miranda rights, things like that. Sixth Amendment, other things. Just leave it at that. What this means is that the defense is coming forward and saying before the trial, this always happens before the trial, rarest case, I've seen it done otherwise, but before the trial, the way the evidence gathered, Judge, was unconstitutional. Under the Fourth Amendment and the Supreme Court's interpretation of the Fourth Amendment, what the police did to gather the evidence violated the Constitution. Therefore, you cannot allow that evidence to come in. If it's a confession, Judge, the confession was gathered without the defendant being given Miranda rights. whatever. Those are the kind of arguments you get. And you could get witnesses testifying in hearings about what the facts were. And then the judge decides it does not involve the jury. It does not have to be the case that that will end, even if the judge says motion granted, evidence suppressed. Doesn't have to end the case, right? In a drug case, in a possession of whatever kind of contraband case, if the contraband is suppressed, the case is over. But other kinds of cases can still go forward even if the confession, say, is suppressed. There could be other evidence. But that's what a motion to suppress is. It's a request to the judge, throw the evidence out because it was gathered in violation of the law.
Is there an age limit for jury pools?
Oh. I think 18. I'm going to have to check. I think it's the same as your voting age. But maybe jurisdictions differ on that. I just really don't know. There is no automatic exclusion for being over a certain age. I know that.
Thank you. I think that's all the questions we have. There may be a couple others that lingered that we think you'll address at the next
Does
session.
that cover all the questions on the cards here? Yes? No? Okay. Yes.
Can phones be brought into the courthouse, especially the jury room? How do you keep the jury from looking up things, especially in a long trial?
Can phones be excluded? I think that's the essence of the question I don't see why not. I mean, the judges make rulings about every other kind of thing. People are so tethered to their phones that I think judges would be reluctant to actually say you can't have your phones. They do yell, scream, shout, and demand that the phones not be used for any purpose except, your childcare, your whatever, but not for your own research. I know there's got to be situations in which judges have basically said no phones because people misbehave. Let's face it. The only place I've ever had my phone, absolutely can't use my phone and you can't bring it in here, prison. When I taught in a prison, no phone. Right? Can't have those. No, you get them. Is that right? Okay. So there's your answer. Federal courthouse, they take your phones. It looks to me like we have exhausted the questions. Let me just tell you what we're going to be doing next week. Same time, same place. We're going to be talking all about capital punishment and death penalty trials. Okay. As I referenced a little bit earlier, these are a different sort of trial. There are some really distinct and important differences. Capital punishment has a very different, not different, but a very distinct history of its own in this country. Given what we're facing as a community in April, it really is important that we spend some time talking about that. So I've really enjoyed talking to you all tonight, and I hope it was helpful. And I look forward to seeing some of you next week, hopefully all of you, and tell your friends. Thanks. Thank you. Email is up there on the